Good afternoon, and welcome to the latest webinar from the American Bar Association section of Civil Rights and Social Justice. This program was developed by the leadership of our National Security and Civil Liberties Committee. Many thanks to Patrick Toomey, John Friedman, and Carrie DeSalle. If you like our work, we invite you to collaborate with us on projects you want to develop and offer to our members of the general public. We are thrilled today to bring you a program entitled FISA Surveillance Reform and the Section 215 Sunset. Our panelists are Ashley Gorski, staff attorney at the ACLU National Security Project. She is a graduate of Yale College and Harvard Law School. Prior to joining the ACLU, Ms. Gorski worked at a New York law firm and served as a law clerk to the Honorable John O. Newman, United States Circuit Judge for the Second Circuit Court of Appeals, and to the Honorable Miriam Goldman Cedarbaum, United States District Judge for the Southern District of New York. Also on today's panel is Alan Rosenstein, Associate Professor of Law at the University of Minnesota Law School. He is a contributing editor at Lawfare. Previously, he served as an attorney advisor in the Office of Law and Policy in the National Security Division of the U.S. Department of Justice, where his work focused on operational, legal, and policy issues relating to cybersecurity and foreign intelligence. He also served as a Special Assistant United States Attorney for the District of Maryland. During today's program, we encourage you to ask questions of our panelists by finding the Q&A tab on the control panel. Here you may submit your questions. There will be time at the end for our panelists to address them. We will be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. Please feel free to leave us feedback or ask questions. And with that, I'll open it up to the panelists to begin their discussion. Thank you.
Thank you very much, Allie. Thanks everyone for attending today's panel. We're looking forward to talking to you about FISA reauthorization. The way we're going to do this is Ashley and I will talk for some time and give some background on what's going on. We'll switch back and forth as we go through our outline, and then we'll open it up to questions. So we'd like to start by giving just a very general background on FISA, the Foreign Intelligence Surveillance Act. FISA, as many of you I'm sure know, was created in 1978 as a response to a series of high-profile, high-level congressional investigations into intelligence abuses. Now, these abuses had occurred in both Democratic and Republican administrations after World War II, culminating in the abuses of Watergate during the Nixon administration. Now, what Congress concluded, or one of the things that Congress concluded, was that while national security and foreign intelligence investigations required potentially more resources and tools than the normal suite of criminal investigation tools offered, the executive branch could not be trusted to do national security and foreign intelligence surveillance on its own. It needed oversight. And the main vehicle for oversight that Congress contemplated in enacting the Foreign Intelligence Surveillance Act was the creation of a new court known as the Foreign Intelligence Surveillance Court, or the FISC. Now, the FISC is an Article III court. It's staffed by Article III judges. There is a preliminary level, then there is a court of review. And the main job of the court is to review government applications for surveillance under FISA. FISA is a very large, very complicated statute, has lots of moving parts. Fortunately, not all of FISA is up for reauthorization this time around, so we can cabin our discussion a little bit. The law has been amended several times in its history. Sometimes these amendments have been permanent, but in the last 2 decades, Congress has tended to add what are called sunset provisions to its expansions. So they will expand it, but they'll say that the expansion will be suspended. It'll expire in a certain term of years unless Congress renews it. One of these reauthorization deadlines is coming up on March 15th. And there are specifically 4 provisions that Congress has to decide whether to reauthorize. The first provision is what's known, let me first list the 4 provisions, then we'll go through them in turn. The 4 provisions are the what's called the roving wiretap. The second is the lone wolf provision. And then the third and fourth provisions are related, having to do with what is called business records and the call metadata program. I'm going to talk about the first 2. These are simpler and less controversial, and then I'll hand it over to Ashley to talk about the call data and business records provisions. So the first issue that's up for reauthorization is what's called the roving wiretap provision. Traditionally, when the government wants to wiretap someone, they apply to a court to get a wiretap on a specific phone number. But if the government believes that the target they're trying to surveil is likely to change phone numbers frequently, they can apply for what is called a roving wiretap. In a roving wiretap, the government doesn't specify in advance which phone number it's going to target. Rather, it specifies the specific individual that the government wants to surveil, and the court gives the government the authorization to wiretap any phone number or any method of communication that that target is going to use. And again, in a situation in which the target is frequently changing the means of communication, is changing phone numbers, is changing email addresses, or whatnot, this can be a very useful authority. Now, this has long existed as part of criminal wiretap law. And in 2001, as part of the post-9/11 USA Patriot Act, Congress created a roving wiretap option for FISA as well. And Congress now needs to decide whether to keep that. I would say that I'm curious if Ashley would agree with me that relative to all the other surveillance issues, this is probably the least controversial one. Given, or at least it's no more controversial than the existence of roving wiretaps in the criminal wiretap context. The second sunset provision, or provision that's about to sunset, is what's called the lone wolf provision. Now, originally, for the government to get permission under FISA for physical surveillance of a suspected, or physical or electronic surveillance of a suspected terrorist, the government had to show that the target was not just potentially engaged in terrorist activities, but was also an agent of a foreign power, usually either a country or usually a international terrorist group, for instance, Al-Qaeda. Now, this limitation, this requirement, was thought to have interfered with an investigation into Zacarias Moussaoui, one of the would-be 9/11 hijackers. This is because although the government suspected him of terrorism before 9/11, they couldn't tie him to a specific terrorist organization. To remedy this and make sure that this kind of issue would not happen in the future, in 2004, Congress amended FISA to allow surveillance of suspected, quote-unquote, lone wolf terrorists. These are terrorists who are not acting on behalf of any particular group. So again, Congress has to decide in its reauthorization whether or not to continue this lone wolf provision. Now I'm going to turn it over to Ashley, who's going to talk about the rest of the frankly much more controversial provisions that are about to sunset.
Thanks, Alan. And just briefly responding, I do think that the roving wiretap provision in FISA is still considered controversial among civil society organizations, in part because of the lesser standards required to obtain a FISA order in the first instance, as opposed to the traditional Title III context. So there has been a push for the lone wolf and roving wiretap provisions to sunset, but I'll be focusing my discussion on Section 215, the other authority that's implicated by the sunset this month, and that's where most of the action has been in terms of public advocacy and congressional debate. So this statute has two key provisions. The first concerns so-called traditional business records, and it authorizes the FISA court to issue an order directing third parties to produce tangible things that are relevant to certain foreign intelligence or terrorism investigations. And these tangible things are defined broadly to include documents, records, and other items, kind of a generic catch-all. The second provision, the more well-known part of Section 215, specifically authorizes the collection of call records from phone companies in international terrorism investigations. And these are records of phone numbers dialed, the time and duration of the call, and they can include other identifying information. Under an earlier version of this statute, the government collected Americans' phone records in bulk from telecommunications companies without any specific target in mind. As the result of legislative reforms in 2015, the statute today technically prohibits that kind of bulk collection. However, it still authorizes the collection of call records on a truly enormous scale. And that's because the government can collect on an ongoing basis call records of targets, as well as the call records of everyone who's in communication with those targets. And this is commonly known as two-hop collection. And the scale of this two-hop collection is exponential. in the literal sense. I think people use exponential very informally, but this is actually exponential collection. In 2018, the government had 11 targets and collected more than 434 million call records from 19 million individual phone numbers under this authority. So for several reasons we'll discuss, the NSA last year ended its call records collection under 215, but the authority is still on the books, and that's one of the elements of FISA that's being debated in Congress today. Before getting in the weeds on those debates, I think it's helpful to walk through a bit of the history behind the government's collection of call records in bulk and how the government came to use 215 for this particular kind of collection. And that story actually begins with the DEA, not the NSA. In 1992, then Attorney General William Barr and his chief criminal prosecutor at the time, Robert Mueller, gave the DEA permission to dramatically expand its collection of call records related to drug crimes. As a result, it was gathering all phone calls from the US to countries with suspected drug traffickers. And at the program's peak, this involved 116 countries. The DEA conducted this collection using administrative subpoenas that on their face allowed the agency to collect records relevant to federal drug investigations. But these subpoena authorities, clearly Congress, when enacting these authorities, had not contemplated that they would be used for this kind of bulk collection. After 9/11, the NSA began collecting its own data on Americans' phone calls, and the DEA program provided a kind of roadmap for this. The NSA's collection was through a program authorized by President Bush known as Stellar Wind, and Stellar Wind involved warrantless wiretapping of the content of Americans' communications in violation of FISA, as well as bulk collection of Americans' internet metadata and bulk collection of Americans' phone records without any FISA court oversight. And just taking a step back, the theory behind bulk collection is that the government develops this enormous haystack of metadata. And through a process known as contact chaining, it can then develop an understanding of a target's activities and associates, and it can find potential new targets based on the chain of contacts and based on this target's pattern of life. The initial legal rationale for Stellar Wind came from John Yoo, and it proved to be deeply flawed for reasons that we unfortunately don't have time to get into today, but it's a very interesting story. And the short version is that in 2003, Jack Goldsmith became the new head of the Office of Legal Counsel and started raising doubts about Yoo's analysis and the legal footing for Stellar Wind. That led to some changes in the program, but it didn't fundamentally change the bulk collection of call records. In late 2005, the New York Times and USA Today broke news about aspects of Stellar Wind, and following that reporting, there was some anxiety in the Bush administration about, again, the legal footing for the program. So in early 2006, the Bush administration decided to shift the call records program so that it was no longer being operated as this unilateral executive branch program, but it would come under the authority of Section 215, and there would be some FISA court involvement. Section 215, as I mentioned, authorized the collection of tangible things relevant to certain foreign intelligence or terrorism investigations using the same language as many administrative subpoena statutes. Again, there's no indication that Congress intended for that language to authorize sweeping surveillance, but the FISC concluded that the Bush administration's bulk collection of call records was relevant to a terrorism investigation. The FISC arrived at that conclusion without issuing any opinion, and it continued to approve the collection roughly every 90 days, requiring phone companies to turn over Americans' records in bulk. In 2013, everything changed with the Ed Snowden disclosures, and at that point, the public finally learned about the breadth of this collection. In particular, Snowden had disclosed one of the FISC's orders that had directed Verizon Business Services to turn over the call records of its customers on an ongoing basis. And it turned out that the ACLU was a Verizon business customer. So we brought suit on the ground that this bulk collection violated the Fourth and the First Amendments, as well as 215 itself. The Snowden disclosures had other ripple effects in the government as well. They prompted the FISC to set forth a legal rationale for the 215 orders that it had been issuing for the past 7 years. They also brought down the DEA bulk call records program, the disclosures did. No one knew it at the time because the program was still secret, but the Justice Department determined that it could not continue both the DEA and the NSA programs because it was publicly justifying the NSA program on the theory that it served national security interests, not ordinary policing. So In the meantime, the ACLU's suit is making its way through the courts, and in 2015, the Second Circuit held that Section 215 did not authorize bulk call records collection. And I think this point really bears emphasis because the FISC had been approving this collection in secret for years, but once the issue was subject to public adversarial litigation, a court of appeals struck the program down, which again speaks to the importance of litigating these significant issues that affect the privacy of countless Americans in a public adversarial context, not in the ex parte context of FISC. One note about the Second Circuit's opinion is that it didn't reach the constitutional questions that the ACLU had raised. And so a very quick aside about that set of arguments. The government had argued that Smith v. Maryland, a 1979 Supreme Court case that many of you are surely familiar with, foreclosed any Fourth Amendment claim, because in that case, the Supreme Court held that the collection of a single criminal suspect's call records didn't constitute a Fourth Amendment search. The court had reasoned that the suspect had shared the numbers he dialed with the telephone company, which was a third party, and as a result, he had no reasonable expectation of privacy in them. But I think that that analysis is really fundamentally different when we're talking about whether the bulk collection of call records invades a reasonable expectation of privacy. Because in aggregate and collected over time, these records are extraordinarily revealing. They expose intimate, very sensitive details about our familial associations, about our professional work, about our religious commitments, and the court in Smith simply wasn't considering the constitutional implications of the collection of this kind of information in bulk. So that was an aside. Coming back to the history and the timeline, the Second Circuit issued its opinion in 2015, and very shortly thereafter, Congress enacted the USA Freedom Act. And the act prohibited the bulk collection of call records, but it explicitly authorizes the two-hop version of the call records program that I discussed earlier, which still results in the collection of hundreds of millions of call records. Most of these records involve individuals who have no direct connection to the target. And this iteration of the call records program operated for 4 years, but the NSA suspended it in 2019, just last year. The program was plagued by compliance problems and specifically improper collection. We learned about these problems through Freedom of Information Act work, and the Privacy and Civil Liberties Oversight Board just released a report that elaborates on several of these issues. One of the key problems with the program concerned the data that was generated by telecommunications providers. The NSA was often receiving incorrect information about the target's calls, and that in turn resulted in the NSA collecting enormous volumes of incorrect second hop data. And to make this concrete, if I'm the target and I've never called Alan, if AT&T's data incorrectly states that I have called Alan, the NSA would then pull all of Alan's calls into its databases without my having any connection to him whatsoever. So once the NSA uncovered these problems, it tried to purge the improperly collected records. But even then it ran into difficulties and it inadvertently retained some of those unlawfully collected records for months. Other factors that played into the NSA's decision to stop the program were cost and relative ineffectiveness. So the Privacy and Civil Liberties Oversight Board report explains that from 2015 to 2019, the call records program cost taxpayers more than $100 million, and only twice in that period did it generate unique information for the FBI that the agency did not already possess. So the compliance programs, the compliance problems, the cost of the program, and the relative ineffectiveness of the program prompted the NSA to wind down the Section 215 call records program last year. And I do want to be clear about one thing, that the government still collects call records related to terrorism investigations without getting a warrant. It has other surveillance authorities like Executive Order 12333 that involve collection outside the United States of enormous volumes of metadata, and the government can still demand that telecommunications companies provide phone records concerning targets. The government just no longer is employing the two-hop program that we've discussed. So I'm going to turn it back over to Alan now for a discussion of the use of FISA in the 2016 campaign.
Thank you, Ashley. So as everyone can tell from Ashley's discussion, the issue of the metadata program, the two-hop program, it's a very complicated one. And if this was all that was at stake here, this would still be a profoundly complicated and difficult set of negotiations over the reauthorization. But there's an additional factor that makes what's about to happen even less predictable than it already was, and that is the issue of the use of FISA in the 2016 campaign, or during the 2016 campaign. So as I'm sure everyone is well aware of from not living under a rock for the last 4 years, during the 2016 presidential campaign, the FBI conducted a counterintelligence investigation into certain individuals connected with the Trump campaign. This investigation was known as Crossfire Hurricane, and it's what ended up becoming the special counsel investigation, which ultimately culminated in the Mueller report's findings that there was pervasive interference by Russia in the 2016 election. Although the special counsel, the Mueller report, concluded that there wasn't sufficient evidence to conclude that members of the Trump campaign had expressly cooperated or coordinated with Russia in that. This was an immensely controversial investigation, especially among, for the president and his administration and his allies. They've routinely referred to it as a politically motivated witch hunt, first by the Obama administration, which of course was a Democratic administration, and later by members of what Donald Trump and his allies like to call the quote unquote deep state, the national security and foreign intelligence bureaucracy within the government itself that is purported to be against the president. Now, shortly after, actually this is one additional piece of information I forgot to mention, so I'll say, all of these provisions that are about to sunset were initially going to sunset back in December. That was the original expiration date. But in November, as part of a must-pass government budget bill, Congress included a temporary 3-month extension for all of these provisions, basically kicking the can down the road to March. Shortly after that November temporary reauthorization, the FBI Inspector General released a report about Crossfire Hurricane. Now, the IG report concluded that the investigation was not politically motivated, that it was started on correct and proper grounds. But at the same time, it did find a large number of very serious errors, some involving just mistakes, others involving intentional misleading of the Foreign Intelligence Surveillance Court regarding surveillance into a particular individual, Carter Page, who was a foreign policy, kind of loosely associated foreign policy advisor to Donald Trump during the campaign. Both sides, or all parts of the political spectrum have claimed the IG report as vindicating their position. In particular, Trump and the president and his allies in Congress have seized on this report to argue for a whole host of FISA reforms. Now, nothing in the report actually has anything to do directly with the authorities that are up for reauthorization. So Carter Page, the individual whose surveillance was at issue in the report, was not surveilled using the metadata program. He was not surveilled using roving wiretaps or the lone wolf provision. But the fact that he was surveilled using FISA has now reopened not just these specific sunset provisions, but large portions of the law up for potential negotiation and reform. This is not only true for Republican allies of the president who are concerned or state what they're concerned about politically motivated foreign intelligence investigations, but there are also a number of Democrats who have long been suspicious of FISA and who are also potentially interested in broader reforms. So with that, I'm going to turn it back over to Ashley, who's going to walk us through some of these reform proposals and the various legislative suggestions that are on the table.
Thanks, Alan. So following the Horowitz report, there were, as Alan was saying, calls for significant FISA reforms. And there's not really time to run through all of them, but I want to provide a little more context for 2 reforms in particular. And the first is a strengthened amicus provision. And one of the greatest concerns about the FISA process is that it's entirely ex parte. And the Horowitz report showed how that ex parte process can breed abuse and misrepresentations and errors and omissions that go unchecked. In 2015, the USA Freedom Act created a system where there's a stable of amici with security clearances who are available to contribute in novel and significant cases at the FISC's discretion to try to open that ex parte process up to some kind of external scrutiny. The FISC also has inherent authority to appoint amici, but it doesn't do so as a matter of course. And following the Horowitz report, there were various calls to expand the role of amici in the FISC, including by appointing amici in every case involving the targeting of a US person. And those calls came from civil liberties organizations. Nunes has a bill in which he's included a provision very similar to this, seeking the appointment of amici in every case involving the targeting of a US person. A second key reform concerns disclosure of FISA applications and orders. And here, some context is helpful. In an ordinary criminal case outside of the FISA context, if the government is going to use evidence that is obtained or derived from a wiretap, the defendant gets to access the wiretap application so that he or she can identify any errors or omissions and can properly litigate the lawfulness of the surveillance. Defendants in FISA cases, however, don't have that opportunity. So you never have this back-end check in the FISA process where a defendant is scrutinizing the FISA application. The statute does authorize disclosure to defendants of FISA applications and orders where a district court thinks that it's necessary. But no defendant, since FISA was enacted in 1978, has ever received access under that statutory provision, which means that defendants are unable to identify the kinds of errors and omissions that we saw in the Carter Page applications. It also raises profound due process problems, and many organizations called for legislative reforms that would require disclosure of FISA applications to defendants. So those were, I think, two of the focal points of the discussion following the Horowitz report. And I'm going to speak briefly now about what's actually on the table in terms of Section 215 reform and broader FISA reform. There are two bills in particular that I'm going to walk through. The first, more aggressive bill comes from Senator Ron Wyden, and it has several co-sponsors. And this bill revokes authority for the now defunct call record program, the 2-hop collection. It expressly prohibits warrantless collection of geolocation information on Americans in accordance with the Supreme Court's recent ruling in Carpenter, where the Supreme Court required a warrant to obtain several days' worth of cell site location information. The bill also prohibits warrantless collection of internet browsing and search history. So when I say the bill prohibits warrantless collection, I mean the government will not be able to use Section 215 to obtain this information without a warrant. The bill also heightens the standard for the collection of tangible things under Section 215, and it requires information collected under 215 to be purged after 3 years if it doesn't contain foreign intelligence or evidence of a crime. The Wyden Bill also reforms FISA's provisions requiring notice to criminal defendants. And here, a little more explanation might be helpful. When the government wants to use evidence that's obtained or derived from certain kinds of FISA surveillance in a criminal prosecution, FISA requires it to notify the defendant. And this is a bare bones notice. It just says, we intend to use this information in the prosecution, this information being information related to information gathered under this statutory provision. The notice doesn't elaborate on what the information was. It doesn't provide necessary context. It doesn't constitute disclosure of the application or order. It's a bare notice. But that notice is still extremely important to defendants because when defendants don't have that notice, they're entirely in the dark about whether controversial forms of FISA surveillance were used in their case. Historically, the government has interpreted its notice obligation extremely narrowly, and it's done so to conceal its use of controversial surveillance. Wyden's bill strengthens the notice requirement, which is extremely important. Also, currently, there is actually no obligation in FISA for the government to notify defendants when it uses information against defendants that was obtained or derived from Section 215. So Wyden's bill also extends the notice obligation to 215. It both strengthens it and extends it, both of which are very important. The bill does not, however, require disclosure of FISA applications to defendants, which is disappointing. The bill also falls short in that it doesn't require amicus participation in proceedings targeting Americans. It does, however, enhance the power of the amici in important ways. The second major reform vehicle is a bill from the House Judiciary Committee led by Jerry Nadler. This bill includes some important improvements, but does not, in my view, I'm obviously editorializing, go nearly far enough, and it doesn't go as far as the Wyden Bill. The House bill, like the Wyden Bill, revokes the authority for the call record program, the two-hop collection. The House bill, like the Wyden Bill, extends a notice obligation to the use of information that's been collected under 215, but it doesn't strengthen that notice obligation across FISA, which is a real problem for the rights of defendants. The House bill, unlike the Wyden Bill, it doesn't categorically limit the types of information that can be collected under 215. There's no express prohibition on the collection of, for example, internet browsing records. The House bill does enhance the power of amici, but it doesn't go as far as many have urged. So after the House bill was introduced, Representatives Lofgren and Jayapal were urging legislators to consider several amendments while the bill was being marked up in committee. And these amendments would have limited the scope of 215 collection. They would have strengthened the notice obligation in FISA. They would have strengthened First Amendment protections, and they would have significantly expanded the role of FISA court amici. It seemed like there was bipartisan support for these amendments, but Adam Schiff in the House Intelligence Committee didn't want to strengthen the bill, and he pressured Nadler to cancel the markup last minute. So now there's tremendous uncertainty about what's happening, whether the House Judiciary Bill will be amended, whether instead we might be facing, if that bill isn't successful, if the Wyden Bill isn't successful, if we might be facing the prospect of an extension that's just essentially a reauthorization for some period of time. Alan's going to talk a bit now about the political dynamics in play.
Yeah, thank you, Ashley. So on top of all of this incredibly complicated set of potential reforms, and again, what one should emphasize, FISA is one of the most complicated regulatory. I mean, it is an unbelievably complicated statute, and so in the best of circumstances, it is very difficult to reform. Even when it is a non-controversial situation, it's hard to reform FISA. It's particularly difficult when you have these controversial issues. But there's actually an additional level of politics that is making an already uncertain process very, very unpredictable, and that is the president himself. When we talk about Congress reauthorization, of course, for Congress to reauthorize something, the president would have to sign any reauthorization. Now, of course, if the president vetoes it, Congress could potentially override that veto, but that is highly unlikely to happen in a polarized and fractured environment. So we have to try to figure out what President Trump himself wants. And here there's a lot of uncertainty. Now, the Department of Justice and the national security, broader national security bureaucracy, and here it's being led by Attorney General Barr, in this legislative situation, they would prefer what is called a clean reauthorization. So basically a reauthorization, perhaps permanently, so no more sunset provisions, a reauthorization that would continue all of these programs indefinitely, potentially into the future. According to news reports, the Attorney General has pitched the president pretty hard on this, arguing that any concerns that the president has with how FISA is currently run, that any of those concerns should not be handled through the legislative process, but that they should be handled administratively. The idea being that Congress would do a clean reauthorization of all these authorities, and then the Attorney General, working with members of the intelligence community, would come up with new sets of guidelines and procedures to deal with any concerns that President Trump might have with how FISA is operating. The president has reportedly rejected this, but he has not actually specified what alternative he would actually like. And so not only is Congress struggling to come up with a reform proposal that a majority of both houses would support, but they don't actually even know what reform proposal the president would ultimately sign, and time is running out. There was some discussion of potentially tying a reauthorization to funding for the coronavirus. That was on the table. That appears to no longer be the case, given that coronavirus funding has just passed and been signed by the president, and there were nothing attached to it in terms of reauthorization for these authorities. But again, it's a very fluid situation. And we really don't know at this point, and I think it's very hard to predict what's ultimately going to happen. On the one hand, you could have a reauthorization for several more months to kind of kick the can down the road. It could be reauthorization for much longer. It could be some sort of reform, and it could also be nothing. If Congress does not act, then these authorities just go away entirely, and in many cases, or at least in some cases, we go back to a version of FISA that existed before 9/11, which is going to have substantial impacts on how the government does this kind of foreign intelligence and national security investigations. So that concludes the lecture portion of this webinar, but we have a lot of attendees, and we'd love to be able to answer your questions. So I have never used the Q&A feature before, but I understand that it's fairly intuitive. So if folks have questions, I encourage you to ask them, and Ashley and I will do our best to address them.
Okay, looks like there aren't any questions. I guess, Alan, one question for you. I am not in the business of making predictions, but if you were going to make a prediction about what you think reform might look like, or whether you think there won't be any reform at all, how do you think this might play out?
Yeah, I'm reminded of that quote from Yogi Berra. It's hard to make predictions, especially about the future. And I again don't pretend to be an expert on congressional politics. I mean, I suspect, if I had to guess, and this is more of a default guess, that the most likely thing will be that the most likely situation will be a temporary reauthorization for some number of months while this is kicked down the line. In terms of those reauthorization, in terms of the reforms, I do suspect that something like a strengthened amicus has a high chance of passing. I would be surprised if it was as strong as requiring the court to appoint an amicus every time an American citizen is targeted, because that would essentially turn what is modeled on a criminal ex parte procedure into an almost full-blown, almost like a suppression hearing, or sort of an ex ante suppression hearing in a sense. But it is certainly possible. As to the notice, a lot I think depends on exactly what precisely how much is being disclosed to the defendant. You know, when I was in the National Security Division, I don't think I'm giving away any secrets here. There was a strong culture of not providing the substantive intelligence information that was going to the FISA court to defendants, and so there is a big difference, I think, between on the one hand providing kind of a basic notice to the defendant and providing a full panoply of the underlying application, let's say, that goes to the FISC. What I do suspect, and at least, you know, if I were the Attorney General, or, you know, if I were in the intelligence community, I would probably be willing to sacrifice the metadata program in its entirety to get a, let's say, permanent reauthorization on something like the lone wolf and roving wiretap provisions. The call metadata program never seems to have produced a lot of useful intelligence, and I think it's essentially been a bigger headache for the intelligence community than it's actually helped, for, again, all the reasons that you described, Ashley, just in terms of the difficulty in administering it. Let me ask you actually a question sort of in reverse, and I'm curious how you think the Carpenter decision that the Supreme Court recently issued is going to impact future surveillance, right? And there are many ways of reading it. And do you think that Carpenter is, you know, requires now the government to essentially get a warrant whenever it wants to do any kind of surveillance, and that this world of warrantless surveillance that we've been living in for the last well, many decades its days are numbered.
I would like to think that its days are numbered, but at the same time, I know in the wake of Carpenter, there was a lot of discussion about the extent to which Carpenter might affect traditional subpoena authorities, and in the days since Carpenter, it's hard to say that Carpenter has fundamentally, upended the traditional regime that existed with respect to subpoenas for third-party records that don't involve location information. But I think one of the important takeaways from Carpenter is that the court was very clear that we should not be uncritically extending Fourth Amendment precedents from an analog era into the 21st century. And I think there's very good reason for that. So I think Carpenter definitely creates many openings for requiring warrants when we're talking about digital surveillance that is extended, that is comprehensive, that is detailed and granular, and exposes the intimacies of one's private life. So I remain optimistic about Carpenter's holding extending to other contexts, for sure. I don't think, though, that Carpenter means that all surveillance will necessarily require a warrant in the immediate future.
Let me ask you a follow-up question. So one thing that I've been thinking about since reading Carpenter, one of the things that I find really striking about that opinion and its potential impacts, and I don't know which way it's going to go, is that the Carpenter court had an option available to it that it seems never to have even considered, which was to say that the surveillance there, which was a week's worth of cell site location information, was a Fourth Amendment search. So cabining, kind of cutting back the third-party doctrine. But that even though it was a Fourth Amendment search, it was nevertheless constitutional and reasonable, because even though the government didn't get a warrant, it did go through some process. And the process it went through was the Stored Communications Act. So, and my question for you is, do you think, I'm curious sort of in the context of you as an ACLU lawyer, but also sort of otherwise, do you think there's space for surveillance systems that are not necessarily based on warrants with the full requirement of probable cause and particularity and all of that, but aren't based on just the government's desire either? Do you think there's a middle ground potentially where we have a system in which we do surveillance that you couldn't do based on a warrant because, let's say, it's more generalized or whatnot, but that it has far more protections than just nothing? Do you think there's a compromise position here, or do you think ultimately it kind of has to be warrants or nothing?
Well, I certainly don't think it has to be warrants or nothing, because even today, looking at the state of doctrine, in cases in which the warrant requirement does not apply because there's some sort of narrow exception, the surveillance still has to be reasonable. And that reasonableness functions as a Fourth Amendment backstop or touchstone. That said, I still think the warrant requirement is extraordinarily important. And I think that collapsing this analysis into a kind of free-floating reasonableness inquiry, ultimately, my instinct would be that it leads to a greater erosion of privacy rights. That's the short take.
Okay.
One thing I do want to highlight from Carpenter, though, too, is that it's a good example of why notice to criminal defendants is especially important, because there, if the defendant hadn't received notice about location tracking, that defendant Carpenter wouldn't have been able to raise these arguments about the constitutionality of that surveillance. It would have gone entirely unchallenged. And it turns out that, in fact, the Supreme Court had a real problem with conducting this kind of surveillance without a warrant. And again, goes to show why notice to criminal defendants is so important, because these cutting-edge Fourth Amendment issues are so often litigated in the Fourth Amendment context, in the criminal context, only when defendants have received notice of the use of these controversial authorities. So that's it from my end. Alan, anything else?
No, I think we've covered the waterfront. Again, if the folks that are viewing have questions, we urge you to ask them. But if not, I'm going to kick it back to our organizer, Allie.
Thanks so much, and thank you all for listening in on behalf of the American Bar Association, Section of Civil Rights and Social Justice. We thank you. For more than 5 decades, the section and its members have worked on hundreds of issues addressing a broad range of civil rights, civil liberties, and international human rights. Today, the section continues to promote policies affecting religious freedom, LGBTQ rights, gender equity, and other significant civil rights issues. Please consider joining our section and getting involved, joining other